This is the FM Gold channel of All India Radio. In the program News Analysis, now we bring you a discussion on Supreme Court judgment on SC/ST reservation in promotion. The participants are Dr. Surat Singh, legal expert, and Satya Prakash, journalist.
Supreme Court has refused to refer to a larger bench its 2006 verdict in the M. Nagaraj case on the issue of promotions in reservation. In the M. Nagaraj case, the Supreme Court had said, while upholding the validity of 4 constitutional amendments, the Supreme Court had said that to give reservation in promotions, the state will have to show existence of compelling reasons, including backwardness, inadequacy in representation, and overall administrative efficiency before making provision for such reservation. Now, the Supreme Court has refused to revisit it. Dr. Surat Singh, how important is this verdict? One, and second, from the point of view of reservation in promotion, what kind of impact it will have on reservation in promotion? Because many decisions taken by various governments, state governments as well as central government, they have been set aside by various high courts and also by Supreme Court in some cases. Now, what will be the legal position?
It was very important that there should be certainty in law. As you are well aware, in Indira Sahni's case, popularly known as Mandal Commission case of 1992, 9 judges have laid down certain principles. One of those was that as far as scheduled caste, scheduled tribe, since they are so backward, so it would be assumed that no independent criteria for backwardness will be insisted upon. So since it was implicit in the judgment of Mandal Commission Indira Sahni, which has been made explicit now in yesterday's judgment, because as you pointed out, Nagaraj has been read down by Supreme Court so as to make it more consistent with 9 judges' judgment, Mandal case. In Mandal case, there were 2-3 main highlights. One, that since reservation is for educationally and socially backward people, so the criteria of backwardness in case of scheduled caste and scheduled tribe by itself will be assumed that they are so backward, you do not need any more evidence. Second, creamy layer is to be worked out of these. That issue still remain open. And the third is that 50% principle as a rule of thumb, because 50% principle will take care of efficiency. So 3 criteria are needed. One is backwardness, on which yesterday Supreme Court said we don't need any quantifiable data to support backwardness.
What the Supreme Court has said, and you will correct me if I am wrong, that once the President has issued notification under Article 341 or 342, depending upon whether it's scheduled caste or scheduled tribe, once that notification has been issued, there is no question of a particular caste or community not being backward. So that will be presumed once that notification is done. And correct. Second stage is then whether that particular caste or community declared scheduled caste or scheduled tribe under 341 or 342 of the Constitution, whether that is to be given reservation or not, and then promotion in reservation, and thereafter. But the Supreme Court here, in this case, is saying creamy layer concept would be applicable. How is it different from OBC reservation so far as reservation in promotion is concerned?
Here the question we are talking about is promotion. About initial for SC/ST, there is no dispute. The question was raised both in Mandal Commission and here also. There will be some segment, some pocket of the same communities which have attained certain higher status advancement because of their higher income, their education, they have attained higher status. So they are as good as so-called forward people. So giving them benefit would really be treating unequal as equal, because benefit is to be given only to backward people and they are no more backward. So the idea was that to really implement the spirit of reservation, all those who are in the creamy layer should be excluded. That was the argument in Mandal Commission. Now, since Nagaraj has insisted that for backwardness you have to lay down quantifiable criteria, similarly you have to lay down for creamy layer also certain limits and all that. Yesterday's judgment said that all these things are implicit in a sense in Mandal Commission's case, and Nagaraj has already made them explicit. But because scheduled caste and scheduled tribe are assumed to be backward, there is no need for proving any evidence. So that's why there is no need to refer it to the larger bench. Because if it is read down in such a manner, as Justice Nariman has done, then it is consistent with Mandal Commission, that is 9 judges bench. So in that sense, they said that no meaningful purpose will be served if we refer it to larger bench, because the way they have interpreted Nagaraj now, that backwardness will be presumed, no quantifiable data are needed, then Mandal Commission and Nagaraj are at par. So there is no contradiction then. So no need to refer it to larger bench.
So far as identification of backward caste or community as backward, the Supreme Court is saying there is no need for quantifiable data because that is in case of SC/ST, because this case is all about SC/ST.
Yes.
There is no need for quantifiable data so far as identification of particular caste as scheduled caste or scheduled tribe is concerned, and that's fine. But still, the rest of the part, the court is still insisting that so far as backward representation in services is concerned, whether it is adequate or inadequate, to identify that, the court is saying quantifiable data is required, and data in terms of a particular cadre, how many people from scheduled caste or scheduled tribe are there. So that data is still required, but I think that should not be a problem because it's about all government jobs. So government would have that data ready-made.
It is about the adequate representation, that whether because of the benefit of the scheduled caste and scheduled tribe, now they have attained. Now, Attorney General Mr. Venugopal argued that the ratio should be in proportion to the population. To that, Supreme Court has said that yes, as far as all India level is concerned, since Member of Parliament seats are also reserved in proportion to the population of scheduled caste
Article
and scheduled tribe. So they said as far as national level is concerned, that can be looked into. But as far as states are concerned, we will leave this liberty with the states and their conditions over there. And beyond that, Supreme Court has not gone that.
But this issue, as you pointed out, it began in 1992. The genesis is 1992 Mandal 1 verdict. Mandal 1 verdict, as you pointed out, the three main points, 50% ceiling,
social and educational backwardness,
and keeping the criminal
caste
out.
Can be the criteria.
Caste can be criteria.
And economic consideration was ruled out in the Sani.
But one important issue that is at the root of the entire controversy now was that the Supreme Court said, Mandal case, that there cannot be any reservation in promotions. At the same time, they said the existing system of reservation in promotion can continue for 5 years, that they permitted it till 1997. But in between, in 1995, there was 77th Amendment that amended the Constitution to allow reservation in promotions. Again, in the year 2000, there was 81st Amendment, which permitted the government to treat backlog of reserved vacancies as a separate group to which 50% ceiling would not apply.
Article 16AA.
Then further, in the year 2000, there was 82nd Amendment which allowed relaxation of qualifying marks and other criteria for reservation in promotion for scheduled caste and scheduled tribe candidates. And again further in 2002, there was 85th Amendment to the Constitution that gave benefit of consequential seniority to scheduled caste candidates who had been promoted through reservation. All these constitutional amendments relating to scheduled caste and scheduled tribe reservation were challenged, and in Nagaraj case, the Supreme Court upheld the validity.
That's correct.
The court has done in this case is that court is saying that in M. Nagaraj case is a good law, only they have corrected it to the extent that backwardness would be presumed in case of scheduled castes and scheduled tribes. Rest of the points, the Supreme Court is saying it is a good law and it has been applied by various high courts and also the Supreme Court in various cases. Where is the problem now? If I ask you, can the government go ahead with reservation in promotion for scheduled caste and scheduled tribe? And if they go ahead, what could be the legal hurdles now?
One thing that, as you have rightly pointed out, Mandal Commission laid down that reservation in promotion is not allowed beyond 5 years, means up to 1997. And then, as you have pointed out, these amendments were introduced, which were upheld in Nagaraj. So, in a sense, Mandal Commission plus Nagaraj together, today is the law. Now, yesterday, Supreme Court has said that's a good law. And that good law means, in case of promotion, reservation is allowed now. Indira Sahni did not allow beyond 5 years. Article 16AA and 16AB, those has also been permitted. It means now government has no problem in making reservation in the matters of promotion for scheduled caste, scheduled tribe. But the three criteria have been again highlighted. Number one, that there should be backwardness, about that no quantifiable data is needed. It is assumed. Number two, that whether they have the adequate representation or not, for that overall strength of the cadre will be seen. And even accumulation can be used because Nagaraj has allowed that. So say in a particular year there is an accumulation, then up to 50% they can choose that year and then there would be carry forward also. So to that extent, the restriction imposed by Indira Sahni Mandal Commission have been relaxed. But the problematic part is still this, that as far as administrative efficiency is concerned, Article 335. So there what would amount as the adequate representation? Should it be in the proportion of the scheduled caste overall in India or in a particular state? Because there might be a state where population of SC/ST may be less than 27%. There might be a state there may be more than 27%. In that case, what will happen? Here, Supreme Court has made an observation that since reservation for Member of Parliament seats are on the basis of national population, so overall, at the all India level, we will say it should be same proportion as the caste, but it has left that leeway at the state level.
Whatever I have read in the judgment, the Supreme Court has tried to distinguish Article 330 with reservation provision. Yes. Article 330 is about political reservation, in which the provision itself talks about proportion to the population.
In the last paragraph of the judgment, Justice Nariman have observed that since there is a representation at national level of a Member of Parliament, so that same proportion at national level can be there. And then Honorable Justice Nariman has observed that beyond that we cannot respond to the suggestion of Attorney General that it should be strictly in proportion of the population even at state level.
But then there are other problematic areas such as the application of creamy layer concept.
Yes.
So far as creamy layer concept is concerned, it is already there in OBC reservation and mostly at the entry level, because OBCs, they don't get reservation in promotions. But scheduled caste reservation is completely different, on a different footing in the sense, apart from entry level, because of these amendments, beginning from 77th Amendment, 81st Amendment, 82nd Amendment and 85th Amendment, all these amendments were upheld by the Nagaraj verdict. Because of these amendments and Nagaraj verdict, reservation age promotion is permissible for SC/ST employees. How do you apply the concept of creamy layer now, so far as ST/ST reservation is concerned?
About creamy layer, Justice Nariman has analyzed the main judgment of Justice Jeevana Reddy in Wonder case. And he has come to the conclusion that majority of the judges there agreed that creamy layer will be applicable to OBC because they come to the same status. So they are the same creamy layer concept they are applying here. And to that extent, creamy layer concept from there has been taken over. But beyond that, they have not elaborated that how do you, when a person ceases to be a member of a community for the purpose of benefit, what that status is.
There is another aspect of this particular judgment, because M. Nagaraj verdict, it was said that creamy layer principle is merely a principle of identification. The Supreme Court has linked it with substantive equality of Article 14, for that matter 15, 16.
Yes. The way Supreme Court has argued about creamy layer in this case is this, that since equal are to be treated equally, once a person from a particular group, individual, not the group, if individuals or family have come out of that backwardness, then they are no more equal with their backward status, particularly in SC/ST. So they have become as good as forward. So since they are equal to forward, including them in backward, they have argued, would be violation of right to equality under Article 14. So they have said that it is subserving the interests of equality if these persons who have become unequal because of their own attaining of new status because of education and social advancement. So to subserve the main interest of equality, they should be excluded from their group.
In fact, the court has said that equality will not be possible if only the creamy layer within that class bags all the coveted jobs in the public sector and perpetuates itself, leaving the rest of the class as backward as they always were.
That's precisely what they have said.
Let's hope after the Supreme Court verdict, whatever the problems for relating to reservation in promotions, that will be sorted out and things will get normal. In the recent past, there have been lots of agitation on this issue. Thank you very much.
Thank you very much.
You were listening to a discussion on Supreme Court judgment on SC/ST reservation and promotion. The participants were Dr. Surat Singh, legal expert, and Satya Prakash, journalist. The program was produced and presented by the News Services Division of All India Radio. This program is also available on our website news.air.nic.in. You may email your opinion about this program at airnsttalks@gmail.com.